Hello there, I'm Lisa. I'm part of the High Cost Family team, and I'm just going to take you through slides 6 to 20. So starting on slide 6, within the screenshot on slide 6, you will see an example of the submitted case plan and how it looks to us. So once you've submitted the plan, it enters our queue. We take ownership of the case and label it 1C, which means one council hourly rates. Once the case manager takes ownership of the case, they will be the person dealing with the case for its entirety. Unless the case manager is on annual leave, once they come back, it will pass back to the original case manager to ensure consistent decision making for the entirety of the high cost negotiations. We process these in date and time order. As it stands today, the High Cost Family team are processing the case plans within 15 working days. However, our target still remains 20 working days to address these submissions, which is important for you to be aware when potentially chasing us for a response of a certain submission. On slide 7, initial checks. We check the start date on the certificate and the registration date is noted. This is to make sure the correct costs are being claimed in the correct stage. We check the scope available on the certificate, for example, child arrangement order, residence contact, etc. We check the cost limit, usually 25,000, and any prior authorities granted. We check the scope to ensure the work being claimed is within the scope of the certificate. On to slide 8. As you can see on slide 8, this shows us the cost limitation of the certificate. This tells us when the pre-contract limit will be, and in this case it is £25,000. At the bottom of the screenshot, you will see where we get the information on any prior authorities granted. In this case, there hasn't been any. Within slide 9, you will see the case example of what we see when checking the scope of the certificate. The case example is Private Law Section 8 for an application for a child arrangements order. The certificate tab gives us the information about the proceedings and the scope limitations of the certificate. As you can see on the screenshot, the case also has ancillary relief proceedings. When we go to the scope limit, it is set up as family help hire. So here, if you were claiming for final hearing, you wouldn't be covered under the scope of the certificate and you would need to submit an amendment to cover you for final hearing. On to slide 11. In the first screenshot, you will see a task tab where all the documents you submit to us for your case plan are kept and where we go to find them. We access the case plan documents. In this example, you can see the solicitor has been super helpful and labelled each document and have provided each item of work to carry out a full assessment. This is not a must, but labelling the documents saves us time processing. The more information you give us with the initial submission means the less likely we are to reject. Slide 12, our initial 4-step process. Once I open the case plan, I read the case summary, just to understand what has happened within the case. For example, was it high cost or was the client particularly difficult? Were there any hearings vacated? Things like that. This is also why we make a note of the scope of the certificate to ensure that all work noted within the case summary relates to the scope available on the certificate. The next thing I would do would be to check any court orders provided. So along with the case summary, I can check to see if any scope issues as mentioned previously. The number of hearings helps us to understand how your costs have been incurred. You will always need to provide a list of hearing dates, including pre-contract. There is an example of the kind of case we assess within the slide. Within slide 13, you will see an example of the type of justification used for enhancement. When it comes to enhancement, it is considered against Section 12 of that cost assessment guidance, basically known as the threshold test, which views the work being done on 3 factors. The factors are exceptional competence, if the work has been done with exceptional speed, or was there any exceptional circumstances. As you see in this example, they have claimed 40 to 50% on non-routine work. It appears that the claim for enhancement is higher than what we would have expected, based on the information that was given to us. For the case, we made a counter-offer of 25%. A 25% enhancement was offered for non-routine work based on the threshold test and the information provided by the solicitor within slide 13. Just a little reminder, the maximum applicable level of enhancement to be sought at county court level is 50%, and the maximum applicable level that can be sought at High Court is 100%. Slide 15, panel membership. Moving on to slide 15. In the example we're using, the solicitor has claimed 15%. So what we would expect to see here, should any panel membership be claimed by a fee earner, that it is clearly shown within the submission. Please take note of the additional information at the bottom of slide 15. On to slide 16 and 17, pre-contract costs. Following a series of meetings with providers, it was declared all cases registered at high cost from the 1st of May 2023 onwards that the pre-contract costs would no longer be subject to assessment by the high cost family team, and that the costs would be assessed by the LAA finance team upon bill submission once the contract had been agreed. This has led to 38% increase in reaching contract agreements quicker. Slide 18 screenshot shows you correspondence being claimed. Pre-contract costs are a good way of assessing reasonable levels of routine correspondence for the future stages. Since the change, we still look at the pre-contract costs. We still check the applicable solicitor rate being applied to ensure that they are correct, so that we can point out but not assess any mistakes that you may have made. The enhancements sought to form part of the contract agreement would also need to be factored into the pre-contract costs before any agreement can be reached or put into place. On to slide 20. It's super important that page 6 is completed in full. If more than one firm has been involved in the case in the pre-contract stage, then we will need both sets of costs within the case plan. Since the 1st of October 2023, you do not have to provide a pre-contract detailed breakdown of costs. Thank you. That is all from me at the moment.
Hello there, my name's Ronnie. I have been a member of the High Cost Family team for the past 11 years, and I am going to take you through slides 20, 21 to 32, which will cover the costs incurred following high cost registration. So if we move on to slide 22, the example that you can see in this slide is basically what the content of the high cost case plan will look like when submitted on an hourly rates basis. What we will do upon receipt and reading the content of this information is we will look at the profit costs that have been requested based upon the work that is being described. Normally within high cost case planning, this work's provided in larger clumps like 30 minutes or 60 minutes or more, rather than the applicable 6 incremental minutes that you would normally find within a billing submission. We would actually prefer it to be provided this way, as it does make things a little bit easier to assess. We will then carry on and look through the additional columns for expert fees, disbursements and counsel fees, and we will assess them as we see them. Now moving on to slide 23, as we are providing you with a live case example, this gives an example of the costs being requested by a provider for an applicable stage 1 over the course of a 2 or 3 month period. Now within this submission, we're giving you some examples which are worded exactly as they were found within the case plan itself on the work being required to complete this stage and the actions of the high cost family team following assessment. So you can see within this example, the solicitor had requested 4 hours for drafting a long and detailed statement on behalf of the client. Now, based on the information that we'd received, which was worded as exactly as it was, this was assessed and an offer of 2 hours was made as an alternative. The solicitor then had an estimated claim for considering the father's further detailed statement and guardian's position statement, which I believe was a claim for around 3 hours. But again, based on the information that we were provided, a counter offer of 1.5 hours was made to the solicitor to be considered. We then had an explanation of work simply stated as considering a report from an expert. The solicitor requested 2 hours for this work to be done. However, given that we would reasonably expect that report to be considered within a timely manner, a counter offer was made of 1 hour only. Solicitor also requested work to be done in regards to preparing a brief to counsel. The solicitor in this example wanted 2.5 hours for such work to be done. However, upon consideration, we believed it more applicable, reasonably applicable, to make a counter offer of 90 minutes only. And within this submission, there was originally a 5-day finding of fact listed in addition to a 1-day directions hearing. But as the case progressed, the finding of fact was then vacated and relisted for a future later date, So within this stage 1, the costs that you can see in the example are applicable to the 1-day listed directions hearing only, not the 5-day finding of fact. And as a result of that, the solicitor in this instance forgot to remove the 5 days travel in relation to the finding of fact hearing. So upon submission, High Cost Family Team removed it for them. So that was just to give you a brief example or an insight as to what we see and how would we approach costs based on the information that we would see. Now, following webinars done in the past, we have taken on board the questions that have been asked previously, and in this delivery we are providing you with some hints and tips that will maybe help you moving forward, in the hope that we can reach an agreement upon the first submission of your case plans as best we possibly can. So if I can take you on to slide 25, this is to give you some hints and tips regarding the expert fees and disbursements that you include within your case plan submissions. With regards to experts, in this example, we're going to use a psychologist, the abbreviation for the psychologist being PSO. Ideally, within your case plan submission, what we would like to see from you, if you are requesting an expert's fee to be claimed or considered, we would like to see the profession of the expert, the applicable hourly rate that will be claimed by the expert, which under most circumstances is in line with the LAA codified rates. If you know how many hours are being requested, please provide that information also. Then, if the fee is going to be apportioned with other applicable parties, please give us an inclination as to that information too. And of course, the total amount that has been requested by the expert. Following that, if there has been any applicable prior authority sought and approved, could you please give us a slight indication as to the approval of prior authority? So what we mean by this is, if you have been granted prior authority for a fee for an expert, in that stage, in brackets, you could simply put PA, and that would give us the insight to then go and check the prior authorities, which Lisa alluded to earlier on when we do our original checks, and we will cross-reference the fee within the case plan with the prior authority that had been sought. In regards to disbursements, we're not going to give you too much in terms of hints and tips, but we would ask you to familiarise yourself with section 10.1 of the Civil Finance Electronic Handbook, just to make you aware of what disbursements are not recoverable from the LAA fund prior to submitting a case plan. And moving on to slide 26, this is some information, hints and tips wise, in regards to the counsel fees that you may be including in your case plan submission. So in regards to proceedings in relation to Section 8 private law, counsel will be applicable to claim family advocacy scheme fees only. This is in regards to cases where an adult has been represented. However, in cases such as Section 8 private law, where representation of a child is applicable, counsel have the option to claim either at FAS rates or the applicable solicitor hourly rate and a level of enhancement if deemed applicable or appropriate. Alternatively, if an hourly rate case is submitted in relation to care proceedings, which will have been granted for as an exceptional case should that request have been provided at the time of high cost registration, then counsel fees in these cases follow the same process as they would with any care case. That is, until the case is listed or has been attended for more than 10 days of main hearings, and by 10 days main hearings we mean finding of fact or final hearings, counsel claim FAS up to that point, but once the 11th main hearing date is applicable, counsel then have the option to apply a CCFS event fee to all of their fees incurred on that case. In regards to proceedings in relation to wardship, inherent jurisdiction and/or appeal proceedings, should there be scope available to do so, Council then have the option to apply an applicable hourly rate of £112.50 per hour or £135 per hour for their work done, dependent on whether or not the council barrister has more or less than 10 years call to the bar. Taking you on to slide 27 now. These are some hints and tips in regards to the profit costs that you may be including within your high cost case plan submission. And within this hints and tips section, I've included 2 examples just to run through with you today, just to give you an idea of how we would go about assessing such costs and how much information it would be helpful for us to receive in relation to these 2 examples. So example 1. I have got an example here for preparing a statement. Now, within our cost assessment guidance, there is guidance available that would suggest that 12 minutes is reasonable to draft a single page document. Therefore, if you request a 20-page statement being drafted, we would maybe apply that applicable guidance to come up with an applicable offer to make to you based on the hours that you are requesting. You can see that in the example provided. Another example that we see quite a lot of is for perusal of documentation, whether it be experts reports or maybe even school reports. Again, as per the cost assessment guidance, the applicable guidance would suggest that 2 minutes per page would be reasonably sufficient to consider a 1-page document. And this hints and tips section is just to give you an indication that, dependent on the information that we are provided with, if there is no inclination as to how voluminous the content of the material is that is being considered, we can only rely on the guidance available to us in order to make you an applicable offer. So overall, the more information that you can provide us with in terms of content with regards to examples such as this, the more likely it will be that you will reach an agreement sooner rather than later. I'm going to quickly take you through to slides 28 onwards, and this is to give you an insight as to how the high cost family team will then record their decisions internally within the CCMS system. So on slide 29, what we will do, once we have received your submission via the case plan task, we will make a record of the costs that were included within that submission. The reason we do this is because should we be of the position whereby we then go back to you via a provider note to advise on any potential reductions that may be necessary in order to reach an agreement, when your resubmission is then sent back to us within the given time frame that we provide you with, which in hourly rates cases is generally a 4-week turnaround, we can then cross-reference the newest submission with the submission that we received previously to make sure any applicable reductions have been made. Moving on to slide 30, what we will then do is we will then write back to you in the form of the provider note, which I have just alluded to. We will thank you for your submission and the date that it was received on. And hopefully this is where we will be able to tell you that we've managed to agree a contract with you upon your first submission. However, as you can see from the example in the diagram, as we are using the live example that we've alluded to throughout this delivery of presentation today, this one makes reference, as you can see, to the observation on enhancement, which Lisa mentioned earlier, whereupon the 40% request was reduced to 25% only. This information is all included within the provider notification and returned to you following the assessment of the case plan. Moving on to slide 31, what we will then do is, following the return of the provider note via the case plan task to the solicitor, we will then make an internal note within CCMS called RE Business Centre. This is only viewable to case managers within the high cost family team, whereupon within the diagram you can see that we will make a record of the case plan received, the date which it was received, and whether or not we managed to agree a contract or the case plan was rejected back. This is really helpful not only to the high cost family team, but also to our customer service team. As should you then contact the legal aid agency to find out whether or not your submission has been dealt with, this information is readily available to our customer service team to be able to give you a quicker response as and when you call to chase a submission. Bearing in mind, the high cost family team will always have a 20 working day turnaround time to address case plans. So if your case plan has not been addressed within that 20-day turnaround time, please try not to contact us until that time frame has elapsed. And finally, moving on to slide 32, what we will then do internally is we will change the status of the case plan task from plan received to plan review requested. And this confirms to us that the case plan task has been returned to you, the provider. And as with all hourly rate submissions, we will give you the applicable 4-week time frame to provide your response and resubmission. In regards to the slides that will be available to you from slides 33 onwards through to slides 37, 38, there is some really helpful links, hints, tips, training slides, and contact information should you need to refer to it at your own discretion. Thank you very much.